Tēnā koutou katoa. Good morning and welcome everyone. This is the 24th day of our hearings on Plan Change 7 to the Land and Water Regional Plan. This morning we start with the submission of beef and lamb. Who's speaking for them?
Lauren Phillips for beef and lamb.
Thank you, Ms. Phillips. We have received the original submission. We have statements of evidence from Mr. Burt, Ms. Crystal and Ms. Coates, and we have also received your summary that arrived last week, I think. And so we have read all of those, and we now would like to hear what you have to say to speak to those, and perhaps if you wish to touch on the main points again.
Thank you so much. May it please the Commissioners, I would like to read from my hearing statement, which was applied earlier this week. I appreciate that you are likely glad to be at the end of this process, and it has been quite a long process, so I don't want to unnecessarily burden you by rehashing something that you are very familiar with. However, if it would please the Commissioners, I would like to read from this statement, especially if you have not had the opportunity to read it yet.
Well, certainly we have read it, but if you'd like to read from it again, by all means do. We want you to feel comfortable about how you choose to present.
Thank you so much. And please, if you would like to interrupt to ask questions, then please do so. Thank you again for this opportunity to be heard in relation to our submissions on the proposed Plan Change 7, or PC7, to the Canterbury Land and Water Regional Plan. My name is Lauren Phillips, and I'm the Environment Policy Manager for the South Island for Beef and Lamb New Zealand. I am responsible for all of the regional and district policy within the South Island, as well as some national level policy, including biodiversity and soils. Beef and lamb is an industry good body funded under the Commodities Levy Act through a levy paid by producers on all cattle and sheep slaughtered in New Zealand. Its mission is to deliver innovative tools and services to support informed decision-making and continuous improvement in market access, product positioning, and farming systems. The organisation is actively engaged in environmental issues that affect the pastoral production sector and in building farmer-specific capability and capacity in these areas to ensure that the industry supports an ethos of environmental stewardship together with a vibrant, resilient, and profitable sector. Maintaining, and where degraded, enhancing the health of fresh water, aquatic habitats and biodiversity across the region is important to the people of Canterbury region. It is important for our economy and it is important to farmers. The sheep and beef sector employs approximately 92,000 people in full-time equivalent roles nationally. Sheep and beef farms are an integral component of Canterbury's primary sector, and they contribute significantly to the region's economy, communities and culture. Plan Change 7 has the potential to affect the sheep and beef sector, particularly extensive farm systems, disproportionately to the sector's environmental impact, and would have the effect of regulation for regulation's sake rather than for environmental benefit. Beef and Lamb has submitted that there are numerous issues with the plan which affect sheep and beef farmers, for which stated relief is sought within the original submission dated 13 September 2019. This statement builds on the substantive issues raised there and introduces the background for Beef and Lamb's expert witnesses who are attending today. I'm speaking to the submissions made by Beef and Lamb to Plan Change 7 submitted 13 September 2019. Beef and Lamb has participated and by giving feedback at several points along the journey to notifying Plan Change 7, including a presentation annexed as Appendix A, and feedback to the Waimakariri Zone Committee, feedback on the Waimakariri's Draft Zone Implementation Addendum, and feedback on 2 occasions to the Orari Temuka Opahi Pariora, or OTOP, on their Draft Zone Implementation Addendum. And if I can please note that there was a figure given in the presentation for Appendix A, which stated 30% reductions. This was a notional figure only, and it was to illustrate what the sort of mechanism might look like for making reductions, rather than being a figure that we are proposing. Beef and Lamb submitted partly in support and partly in opposition to Plan Change 7, and this statement will focus on 5 main topics where Beef and Lamb has opposed provisions in the plan. These topics include commercial vegetable growing operation definition, highest groundwater level definition, indigenous freshwater species habitat definition, requiring higher activity status resource consent applications for farmers with management plans than for farmers with farm environment plans, or FEPs, and provisions which reinforce grandparenting of nutrients in the Waimakariri area and OTOP subregions. The effect of the proposed provisions in these 5 topics is regulation for regulation's sake, often disproportionate to the risk an activity poses to the environment and without actual benefit to the environment. Topic A is commercial vegetable growing operation. And commercial vegetable growing is an intensive system with high inputs and is generally classified as a high-risk activity for adverse environmental effects. And we're looking at, for example, where you might have a dairy farm, an intensive dairy farm that puts on several applications of 100 kilos of urea. Maybe they might put on, for quite an intensive system, 6 applications of urea per year, and that will be 1 per month generally. You are looking at a situation where commercial vegetable growing might put on a ton or over a ton of fertilizer in a single application. That's where I mean that it has high inputs. It is a complex system, however, which is difficult to manage with the rules which might manage effects from pastoral systems. One size does not fit all. Environment Canterbury has introduced a suite of rules specific to commercial vegetable growing to try to address this. We have opposed the proposed suite definition of commercial vegetable growing operation and therefore the associated suites of rules, because the proposed definition currently includes the words "and pasture." As discussed in the evidence by Mr. Andrew Burt and Dr. Jane Crystal, sheep and beef farmers often have diverse income streams. This can and does include arable and vegetable crops for human consumption, whether by the dry stock red meat farmer herself or where the farmer leases land out to a vegetable grower. So, for instance, potatoes and table peas are a common example of vegetables that are grown by our farmers. Following a cycle of grazed pasture between crops helps to repair soil structure, reduces disease and pests, and raises carbon matter in the soils. So it is a cycle which provides for the long-term sustainability in using the land for vegetable growing. The relationship between vegetable growing and pastoral systems tends to be with the dry stock sector because dairy land is very rarely used for that purpose. This means that the words "and pasture" will affect the sheep and beef sector more than other pastoral systems. Sheep and beef pastoral systems are recognised as predominantly low-risk activities, however. This is supported by Dr. Jane Crystal's evidence in support of beef and lamb submissions on Plan Change 7. In our submission, by including pasture in the definition of commercial vegetable growing operation, these regulations intended for high-risk activities are now extended to cover low-risk pastoral farming. It is submitted that this is inappropriate, as the wording captures the situation where crops for human consumption might occasionally be grown as an intermediate crop in a predominantly pastoral operation. The notified definition captures all rotations in a commercial vegetable growing operation, which may include an extended pasture phase, and therefore the regulations associated with it would extend to low-risk pastoral systems. Blanket application of the proposed rules is inefficient and ineffective in controlling the activity relative to the significance of the emissions. It would restrict the sheep and beef farmers unnecessarily and require them to obtain a resource consent for the pasture phase. It would therefore also discourage the relationship between pastoral and vegetable growing, which is beneficial for the soils, because pastoral farmers would prefer to avoid the regulation and the need for resource consent. Beef and Lamb supports the Section 42A recommendation in Appendix E to remove the words "and pasture" from the definition of commercial vegetable growing and is neutral on the Section 42A recommendation to remove the word operation. The revised definition would read as follows. Commercial vegetable growing is a subset of farming activity and means the growing for the purpose of commercial gain of vegetable crops for human consumption on one or more land parcels held in single or multiple ownership, whether or not held in common ownership, that constitutes a single operating unit but excludes vegetable crops grown under cover. Topic B is highest groundwater level. Plan Change 7 proposed to delete an existing high groundwater levels definition and replace it with a new one. Namely, highest groundwater level means the single highest elevation to which groundwater has historically risen that can be reasonably inferred for the site, based on all available hydrogeological and topographical information. Beef and Lamb has opposed this proposed definition out of concern that the definition is not time-bound or current or near time-bound to current or near historical groundwater levels, and further concern that the suite of rules associated with this definition applied to existing activities as well as new activities, as confirmed by one of Canterbury Regional Council's Plan Change 7 authors, Andrea Richardson, by email on 2 September 2019. The notified definition is considered inappropriate for temporal range and lacks certainty for plan users. Beef and Lamb understands the need to respond to and plan for changing groundwater levels, weather events, and even season shifts resulting from climate change. And the Canterbury Regional Council does need to do so. The existing definition used to manage the suite of rules mentioned above is seasonal high water table, and it is defined as, at the time the activity was established, the highest elevation that the water table has reached between the months of June and August inclusive. That definition is based on an assumption that the highest rainfall season is over autumn and winter, which means that the water table is highest over June-August period. Due to a number of factors, including climate change, this assumption cannot always be relied on, and having the definition tied to those months may not allow Canterbury Regional Council the flexibility to respond to changing environments, particularly in response to the effects of climate change. Beef and Lamb's concerns are that the proposed new definition, A, fails to provide for changes in groundwater level, because historical and topographical evidence of groundwater levels are inherently backwards looking, rather than allowing for a dynamic change now and in the future. It therefore fails to provide actual environmental benefit. And B, provides no certainty for farmers or standardization in how the definition is applied. Failing to bind this definition temporally means that one could technically go back over an unlimited time span to derive the highest groundwater level. For instance, it is common knowledge that much of the Christchurch district and even Christchurch City was underwater when European settlers arrived. The landscape has been significantly altered as a result of large-scale wetland and high groundwater drainage. However, historical and topographical information will indicate that where we now have houses, pasture, and infrastructure, that land can reasonably be inferred to have been below the highest groundwater level. This is a perverse outcome. It is impractical, and it gives Canterbury Regional Council an almost unfettered discretion in how the rules associated with this definition are applied. C, makes a number of normal practices on farm, such as existing offal pits, unlawful where they have been established in good faith based on the regulations at the time, and where moving them may be unsafe, unnecessarily expensive, or even impossible. D, requires the farmers to obtain resource consent for existing or new activities where doing so will not necessarily lead to actual environmental benefit, representing regulation for regulation's sake, along with the associated cost at the farmer's expense. The Section 42 report addresses the issue by recommending that the highest groundwater level definition be amended to the single highest elevation to which groundwater has historically risen that can be reasonably inferred for the site, based on all available relevant hydrogeological and topographical information. Beef and Lamb submits that this amended definition fails to address the material issues with the definition itself as laid out above, and opposes that definition. In its submission of 13 September 2019, Beef and Lamb proposed an alternative definition to address all of the issues laid out above, and to allow Canterbury Regional Council the flexibility to address a changing environment and water tables while managing the activities that might adversely affect groundwater. Highest groundwater level means, at the time that the activity was established, the highest elevation that the water table has reached, taken over an average of the preceding 10 years. Beef and Lamb submits that this remains the most practical approach which offers actual environmental benefit. Beef and Lamb is concerned about the number of provisions, including this one, which would effectively force permitted activity land users to obtain a resource consent for farming activities. In fact, when looking at the proposed Plan Change 7 as a whole, it can appear that Canterbury Regional Council are trying to capture as many farming activities under resource consent, irrespective of risk to the environment and despite providing permitted activity pathways for low-risk systems in the first place. For example, proposed Rule 14.5.17 subsection 7 sets a threshold of 20 hectares of land for land in winter grazing where any part of the landowner's property is in the high runoff phosphorus zone, even if the winter grazing is not located in that zone. BFNAM also notes that consents for farming activities can result in the consent holder being captured by requirements to make percentage reductions in nutrient losses under provisions proposed by Plan Change 7. Topic C. Indigenous freshwater species habitat. BFNAM has opposed the definition of indigenous freshwater species habitat and therefore all of the associated regulation that it pertains to. BFNAM appreciates that Canterbury Regional Council would like to protect habitat for indigenous freshwater species to ensure that we can enjoy New Zealand's living taonga into the future. The requirement to protect has only been strengthened by recent amendments to the National Policy Statement for Freshwater Management that increases protections for indigenous freshwater species and their habitats. The overwhelming feedback that BFNAM has had from its farmers is that they too value our indigenous species and want the same outcome. However, how one achieves that outcome needs to be fair, sensible, and grounded in reality. The Indigenous Freshwater Species Habitat Map Layer identifies reaches of water bodies that coincidentally fall largely on sheep and beef farming areas. Many of these farms will be low risk, extensive, and permitted activities. And as such, there is a proportionately lower levels of regulation for those systems. The implications for extensive pastoral systems are disproportionate to other plan users due to the greater spatial complexity of the habitat in the higher order streams found in such farm types. Significant spatial coverage can be expected inside each extensive sheep and beef farm compared to lowland intensive operations. Therefore, because our farmers have proportionally more landscape to which the proposed rules apply, a more equitable approach is sought. As discussed in Ms. Annabelle Coates' evidence, the map layer is fundamentally flawed. The definition is tied directly to this map layer, and the rules and policies that follow are directly tied to the definition, which presents a problem for the entire package of regulation. Without expanding Ms. Coates' evidence, the flaws can be summarised as A. The layer is based on records which may no longer be current, and B. The approach to identifying protected reaches is inconsistent, and C. There are inaccuracies within the map, and D. Some of the reaches identified have little or no ecological value. The regulation associated with the layer will have significant implications for the farmers who are affected by it. BFNAM submits that the regulation package should be amended to avoid regulating those farmers for regulation's sake, with the associated cost, without providing actual environmental benefit. Allowing the regulation package to become operative as is would be imposing regulations completely disproportionate to risk, especially for those reaches that no longer exist, have low or no ecological value, cannot support indigenous species for one reason or another, or where the species are simply not present. BFNAM recognises that mapping, surveying and modelling is a major undertaking, and this may have contributed to some of the flaws we see with the map layer in order to reduce costs and time, particularly where outdated records have been relied on to identify protected reaches. BFNAM proposes to amend the definition instead, as a more cost-effective, faster and more equitable solution. All of the map layer flaws identified by Ms. Coates can be resolved by accepting BFNAM's proposed amendment to the definition, which is to ground-proof the reaches with a suitably qualified and experienced practitioner, or SQEP, provided by Canterbury Regional Council at the Council's cost. BFNAM's proposed amendment is as follows. The indigenous fish species habitat means an area identified as indigenous freshwater species habitat on the planning maps, and which provides habitat for at least one of the freshwater species listed below, where the presence of that species has been confirmed by a suitably qualified and experienced practitioner. BFNAM further submits that the ground-proofing by a SQEP should be undertaken before Canterbury Regional Council proposes a blanket policy or shifting costs to individual landowners. Topic D. Management plans and farm environment plans. The plan provides for lower risk pastoral systems through permitted activity pathways, recognising that these lower risk systems should be managed under proportionately less onerous regulation. As part of this pathway, the plan allows permitted activities to have a management plan prepared in accordance with Schedule 7A instead of a farm environment plan prepared in accordance with Schedule 7. The MP is less detailed than a FEP, and it does not require a nutrient budget. Beef and lamb supports the exemption from requiring a nutrient budget. Dry stock farms, or red meat farms, are diverse and often complex, and dry land farms especially so, in order to make the most of limited resources that are vulnerable to elements outside of the farmer's control, for example, climate and markets. Complex systems in practical reality are also complex systems in overseer. Sheep and beef farms easily require dozens of hours to model in the nutrient modelling program, incurring significant cost which does not result in meaningful outcomes for managing invariably small nutrient losses to the environment. The permitted activity pathway recognises the need for regulation to be proportionate to the risk of adverse effects to the environment, and means that those land uses which present a lower risk to the environment do not have to produce a nutrient budget or be regularly audited at the landowner's own cost. Incidentally, sheep and beef systems tend to fall under the permitted activity category more than any other pastoral system. This means that sheep and beef farms are more likely to have an MP than any other pastoral system, and extensive systems in particular, the lower risk, lowest impact, lowest emitting system, and that they are least likely of any pastoral sector to hold a resource consent to farm. Plan Change 7 proposes consenting pathways with low activity status for activities like silage pits or fertiliser application where contaminants might enter water, and the take and use of surface water and groundwater. These pathways, however, all require the applicant to provide a farm environment plan, FEP, and therefore a nutrient budget. This effectively rules out permitted activity land users from utilising that consenting pathway, and the next available consenting pathway is often extreme. For example, proposed Rule 5.40 offers a restricted discretionary activity pathway, and failure to meet the conditions of Rule 5.40 mean that a permitted activity applicant would have to default to a non-complying activity resource consent application. We do not agree with the Section 42A officer's report that this is consistent through the plan and therefore should be carried through with Plan Change 7. Provisions 5.40, 5.40A, 67A, 8.59, 14.5.4, 14.5.7 do not provide for management plans, and therefore permitted activities, and therefore sheep and beef farmers. This is excessive and effectively either penalises land users for using the permitted activity pathway that the plan offers, or it is disingenuous because it undermines the permitted activity pathway by compelling land users to have a FEP anyway. Beef and Lamb submits that Canterbury Regional Council should act in good faith, and that MPs should be provided for in the above provisions, regardless of past regulations in the plan which are not up for submission in Plan Change 7. Topic E, grandparenting provisions. In implementing the National Policy Statement for Freshwater Management several years ago, Canterbury Regional Council chose to try to reduce nutrient contamination losses to fresh water through a grandparented nutrient allocation framework. In a grandparented nutrient allocation framework, one is locked into historical nutrient losses as determined by an overseer budget. A baseline average of several years is normally selected to set the losses to, and one may generally not increase losses to water over and above that baseline figure. In Canterbury, the focus has been on nitrogen losses because this is the easiest to model in overseer as the N number and leaches directly into water, whereas pathways for sediment and phosphorus are more complex and harder to model accurately. They are also better managed through mechanisms such as a farm environment plan. From there, Canterbury Regional Council has generally required percentage reductions from those grandparented losses from consented farming activities, which generally represent higher impact systems with high N numbers. Plan Change 7 proposes provisions which require percentage reductions in the Waimakariri and OTOP. The effects of grandparenting can be understood through an analysis of Farmer A and Farmer B. Farmer A's N number is 68 kilograms of nitrogen per year. Farmer B's N number is 12 kilograms of nitrogen per year. Both farmers are grandparented to those N numbers and may not increase over them. They are also then required to make 10% reductions in their nitrogen losses as modelled in Overseer. At 68 kilograms of nitrogen per year, Farmer A's system is a high-impact, high-risk, intensive system, regardless of sector, and would generally have high inputs. There are many inefficiencies which can be addressed in a farm with such a high N number, and even when Farmer A has tweaked these inefficiencies to achieve a 10% reduction, the system still leaches 61 kilograms of nitrogen per year. It is still a high-impact, high-risk, intensive system with a high N number. At 12 kilograms of nitrogen per year, Farmer B's system is a low-impact, low-risk, reasonably extensive system with low inputs. There are few inefficiencies in that system, and the farmer will likely already be farming to the natural limitations of the land. Failure to observe those limitations would have already resulted in environmental collapse, usually seen in soils, and/or stock would have starved, or the business would have failed. This means that there is little Farmer B can do to further reduce from 12 kilograms of nitrogen per year to achieve the 1% reduction, or the 1 kilogram reduction. Apologies, that should be a 10% and 1 kilogram. Dr. Crystal expounds on the limited levers that low-emitting systems have to reduce their nitrogen losses. Farmer B is also less able to respond to market demands, changes in technology, drought, or to make any changes in the farm system because Farmer B's N number is too low to allow for any flexibility within the system without the risk of increasing in nitrogen losses, at least by a couple of kilograms of nitrogen per hectare per year. Off-farm, relative land prices are affected because the potential that Farmer B's land had in terms of land value is diminished because Farmer B can never intensify, even if Farmer B never intended to anyway. This reduces the equity that Farmer B holds in the land and reduces the farm's resilience because there is less equity to borrow against to replace infrastructure, to buy feed in a drought, upgrade to water reticulation in response to stock exclusion regulations, or tide the farm over in a year where prices are low. Farmer A's land is not affected in the same way. The higher the N number, the more flexibility the land has, and therefore the more value the land has. This is how grandparenting has played out in Canterbury, with the effects most keenly experienced in areas like North Canterbury, where the divide between extensive, often hill and dry land, and intensive, often flat and irrigated, is pronounced. The sheep and beef sector is overwhelmingly Farmer B. As Dr. Crystal has shown in her evidence, the sheep and beef sector is a lower risk, lower impact system, and this is the case even with the most intensive or irrigated most intensive or irrigated sheep and beef systems. Sheep and beef farms in Canterbury tend to be dryland and or extensive, however, with low N numbers. This is in large part due to large-scale conversion of sheep and beef land on the flatlands to dairy, as shown in Mr. Burt's evidence. They are disproportionately adversely affected by the grandparented nutrient allocation system. We note that Section 42 report at page 346 has rejected 346 and 347, I believe it is, has rejected beef and lamb's submission on the grounds that, well, partly on the grounds that the alternative nutrient allocation framework that we propose allows for flexibility and development for low-impact farm systems and effectively favours low-impact farm systems. And in response to that, that is true, it does. Grandparenting favours high-impact farm systems and allows them to continue being high-impact farm systems even where you do have a staged reduction. And my response is that why shouldn't the nutrient allocation framework favour and incentivise low-impact, less intensive farm systems which farm within their environmental limits? As explained throughout the Plan Change 7 journey and reflected in all of the beef and lamb feedback to Canterbury Regional Council and every plan change submitted on, The contaminant losses from extensive dryland farms, as well as the nitrogen attenuation rates from that land, are different to attenuation rates for irrigated land. The different farm systems should not be broad brush regulated under the same risk assessment, as they do not pose the same risk of nutrient contamination to the freshwater environment. Grandparenting nutrients is inherently inequitable. It rewards land users who have had the greatest adverse effects on the environment, while penalising landowners who have had the smallest impact on the environment and have been farming within the natural limits of their land. The low-impact land users take the haircut for high-impact land users. Grandparenting nutrients also fails to achieve meaningful environmental outcomes. While the approach appears to be harsh, and it is harsh to farmer B, it effectively allows high-impact systems to continue having a significant effect on the environment. In RMA terms, the concept of grandparenting is normally about specifically recognising or providing for activities that already exist to continue producing their existing level of effects, either permanently or for a defined period, but imposing immediate obligations on new entrants. As the Environment Court observed in its decision on the Horizons 1 plan, it is understandably favoured by existing operators who rationalise it by reference to their prior investment. BFNAM proposes a more equitable framework which rewards efficient systems and provides for environmental benefit, incentivising farming with environmental limits, based on the natural capital framework. This framework has been set out in BFNAM's submission on Plan Change 7 and BFNAM's Principles for Nutrient Allocation, annexed as Appendix B, the mechanism for which has been simplified in Slide 5 of Appendix A. The floor established by a natural capital approach is the environmental limit of a catchment. Natural capital proposes that, provided land users remain within that floor, they have the flexibility to change and adapt their system in a way that grandparenting does not allow. Those land users who are operating above the floor need to change to farm within environmental limits. Farming out above the environmental limits is arguably the reason we have water quality issues in New Zealand. They need to be given time to do so, but those land users must be held responsible for their own contaminant losses, and other land users should not be penalised to soften the impact of change on land users who do not farm within environmental limits. BFNAM has opposed provisions, and I won't read those all out, on the following ground. A, the measures and provisions proposed represents a one-size-fits-all approach that grandparents nutrient losses to the environment. This approach does not provide for the economic or social well-being of the land users and the communities affected by it, and it is also not the most effective way to achieve the desired environmental results. B, nutrient allocation or allocation should be based on principles of sustainable management, including providing for future generations, which incentivize land use and land use change appropriate to the soils, climate, and achievement of water quality outcomes. Nutrient allocation and methods for managing nitrogen should not reward current land uses and practices where nutrient discharges exceed the assimilative capacity of soils and water. C, management approaches should ensure that those activities and land uses which are contributing the most to the over-allocated parameter bear the majority of the cost, reducing the over-allocation, or polluter pays principle. D, Plan Change 7's proposed approach means that land use changes with the lowest reaching rates or impacts on the environment, arguably not the intended target of the proposed provisions, will be the most affected by the proposed provisions. They have the fewest levers to pull in terms of reducing already lower nutrient losses, and it is harder to make reductions from an already efficient system. The proposed framework can make it harder for a system to remain viable, while the higher impact systems are able to remain operating due to the greater flexibility in their system. This is a perverse outcome, which would have corresponding social and economic repercussions for the communities that the land users of these systems are part of. Both Waimakariri and OTOP subregions set permitted thresholds of irrigation and winter grazing, both high-risk activities, and require percentage reductions in nitrogen losses for consented farming activities. Specifically for the Waimakariri subregion, Table 8.9 essentially sets a floor of 10 kilograms of nitrogen per year leaching rates for non-dairy systems and 30 kilograms for dairy systems by stipulating that the required reductions for land uses are captured by the percentage reductions in the table do not need to be made if reductions are equal to or less than 1 kilogram and 3 kilograms of nitrogen per hectare per year, respectively. The lower nutrient loss floor proposed in Table 8.9 is based on grandparented nitrogen numbers rather than environmental limits, and it inadvertently recognises the low environmental impact of the sheep and beef sector. The huge difference in both the respective floors and the total percentage reductions supports that, despite the fact that some sheep and beef farms are intensive, use winter grazing, and or irrigate part or all of their effective land area. If the lower floor is not, in fact, recognising the significantly lower risk that sheep and beef systems pose to freshwater quality, and the difference in floors is not representative of the lower leaching rates, then there would be no justification in the difference in floors because the floors set are not based on environmental limits, or they would be the same for both sectors. The percentage reductions for Waimakariri would need to be made by anyone within the nitrate priority area who requires a resource consent for farming land use, which covers the majority of the Waimakariri Plains area. As submitted and as supported by the evidence of Dr. Crystal, a floor of 10 kilograms per year is set at, essentially, dry land loss rates for dry stock systems, when there is little or no irrigation and or winter grazing. Achieving the required percentage reductions might, in fact, not be possible while continuing those activities land users hold a resource consent for, and for which the system is under the percentage reductions framework in the first place. Under Table 8.9, all other farming sectors appears to be taking a haircut to preserve flexibility for another sector's systems through a floor which is unfairly prejudiced against them, and percentage reductions that rob them of their ability to exercise their resource consents for winter grazing or irrigation, even as Table 8.9 recognises all others' lower impact on the environment. Specifically for the OTOP subregion, blanket nitrogen reductions are once again required, and these reductions would need to be made by anyone who requires a resource consent for farming land use and is in the high nitrate concentration area. Under Plan Change 7, this would particularly target those systems with more than 50 hectares of irrigation and or a certain threshold of land in winter grazing. Unlike in proposed changes to Section 8 Waimakariri, no default floor is established below which reductions no longer need to be made. And this is significant because the reductions apply regardless of whether the original actual or assumed good management practice leaching rates. A farmer whose system leaches a negligible 8 kilograms of nitrogen per hectare per year would be obliged to make percentage reductions which deliver no real benefit to the environment while having a devastating effect on the farm business. As with the Waimakariri, lower impact systems with efficient practices that are nevertheless required to hold a resource consent may not be able to make the percentage reductions in order to continue the activities they hold to a resource consent to practice, and will be the most harshly affected by the proposed reductions. Higher impact systems, Farmer A, are better able to absorb the reductions the higher the loss is. In terms of polluter pays, the greater the pollution, the greater the reward. These provisions give some indication of why grandparented nutrient allocation framework encourages gaming the system to the detriment of the environment. In conclusion, sheep and beef farmers are actually key to the fabric of the Canterbury region. They are there for the long haul, and family is the primary reason behind on-farm decisions. Sheep and beef farming systems are predominantly low-risk activities, and the regulation that applies to these systems should reflect the level of risk. To remain a resilient, vibrant and diverse sector, sheep and beef farmers require flexible land use and the ability to optimise their farming business within the environmental limits of their property. Regulation should also tie into actual environmental benefit. Sheep and beef farmers want the same outcomes as Canterbury Regional Council, which is a healthy environment where taonga can be enjoyed by future generations. How that is achieved, however, should be through equitable, sensible measures which deliver real benefits. Regulation should reward those farmers who farm within environmental limits rather than penalising them. As it is currently written, proposed Plan Change 7 does not achieve this. Lower risk systems should be managed under proportionately less onerous regulation and under a fair and equitable nutrient allocation framework that rewards them for treading gently through this world. If it pleases the panel, I would like to comment on a couple of matters which arise from the Section 42A report.
Yes, thank you.
Thank you very much. The first is paragraph 4.19 on page 252, which is in reference to Beef and Lamb's opposition to the word avoid in several provisions. And the officer has said that it effectively will not have a prohibitive effect. And with respect to the learned author, King Salmon, the ruling in King Salmon does suggest that it will have a prohibitive effect, because avoid effectively means no, it means that should be prevented from happening. The second point that I wanted to just briefly comment on was paragraph 6.42 on pages 444 and 445, and this is in regards to a provision on stock water takes, where we were asking for more flexibility and more protection for stock water takes. And this was especially around allowing for a more permissive pathway for stock water takes. If you just give me a minute and I will provide the rule number to you. Thank you very much for your patience. So this is policy 8.4.16, which is where we have stated that stock drinking water is not always exclusively provided through community water supplies, and water permits may be required to supplement permitted takes and provide sufficient volumes for reasonable stock water use. So we submitted that stock drinking water should be provided for under clause B of policy 8.4.16. And the author has stated that an application for a new consent for stock drinking water would likely be the result of establishing a new farming activity or intensifying an existing activity, and that it is their view that making water available for a new or intensified farming activity at the expense of meeting freshwater outcomes is inconsistent with objective B, etc., etc., and they recommend rejecting the submission from Beef and Lamb. Again, with respect to the learned...
Sorry to interrupt, but
yes, sir.
I've gone to the page in the section 42A report that
yes.
you referred us to.
444.
I'm not quite seeing where we are.
Sorry, that's...
Could you just...
Yes, that's page 444 at the bottom.
444?
Yes,
sorry,
paragraph 6.42.
642, thank you.
Yes.
I'm sorry, but please continue.
Thank you. Thanks. So again, with respect to the learned author, this demonstrates ignorance about the systems that this author's recommendations will affect. Where you have extensive and dry land farms, these are already at the intensivity that they can manage, and this will not necessarily be focused on stock drinking water. Feed, topography, and the ability of the soils to support livestock will be the primary factors driving the intensivity of that farming system. And so when this submission was written, it was in mind of the fact that greater stock exclusion provisions or regulations were on their way through the National Environmental National Environmental Standards, which have now landed. And so if the animals cannot drink directly from waterways, farmers will need takes to reticulate their water systems. Additionally, to avoid certain effects on water systems, reticulation is particularly preferred. For example, sheep will prefer to drink from troughs rather than waterways, which can assist with treading on banks. Furthermore, we anticipated that we might see further protections come in for water, especially surface water takes. And this has been validated by changes to the National Policy Statement for Freshwater, where we likely will see greater protections come in for water quantity to provide for environmental health. And so we would like to see a mechanism provided for farmers to better access stock drinking water where they don't necessarily have the ability to rely on permitted takes in future. This is more, this is not about allowing for intensified or new activities. This is existing activities where prior sources that have been relied on for stock drinking water, which is a basic necessity, are no longer available as a permitted activity. That concludes the statement from Beef and Lamb. Thank you very much for your attention.
Well, now, there may be some questions for you, Ms Phillips. Commissioner Van Voorthuizen, any questions of Ms Phillips?
Yes, I do. Having already read your evidence previously, I have 4 issues I'd like to discuss with you. They are highest groundwater level, the iFish definition, your issue about management plans versus farm environment plans, and lastly, just to briefly touch on grandparenting. So turning first to paragraph 24B, on page 6 of your hearing statement.
Thank you.
So I take it the point you're making in paragraph B is that these historical levels when Christchurch was under a lot of water would mean that those levels simply aren't relevant?
Correct.
Just turning to your paragraph 24C, I take it, or I'm assuming that farmers wouldn't want offal pits, for example, to be subject to groundwater.
That's correct. And there are existing rules to protect groundwater from leaching from offal pits, for example. What our submission is that where they have put in offal pits and they've followed the rules to ensure that there is a 3 metre, for example, separation between highest groundwater and the base of the offal pit to provide that protection, this may no longer be relevant regardless of whether or not the groundwater has risen. And as stated in the submissions, it is not actually always safe or possible to move those existing pits. So it was confirmed by Canterbury Regional Council that this will apply to existing activities that are already established and they may be permitted. And this is where the issue comes in. Where we have new activities and it's been established that actually groundwater levels will be affected, this is an entirely reasonable situation that should be taken into account. But for the existing ones which were established in good faith and which it is actually not practical to move those, it is not fair to require resource consents for those activities.
Just looking at your definition in paragraph 27, just got a couple of practical concerns about what you're suggesting. You've suggested a preceding 10-year period. What if the highest recorded groundwater level occurred 11 years ago?
That sounds like an outlying event, sir.
But it's a real event.
It is a real event, yes. But if we are looking at a flood situation, where it's a 1 in 100-year flood situation, for example, as, for example, in Little River, this generally is accepted that when it does flood, and not regularly, even the shops might be a metre underwater. In that case, you are looking at an unusual situation.
So a highest groundwater level that was reached 9 years ago is valid, and one that was reached 11 years ago is invalid. Is that what you're saying?
I take your point. 10 years is to provide a span of time which might offer enough range in in events. I think that if we take the point that, well, what about 11 years, what about 12 years, one can really definitely go back through the millennia to look at all of the topographical and historical evidence. However, at some point one does need to set a limit.
Yes, one would only want to consider records that were relevant, wouldn't they?
Yes.
The other concern I have with your suggested wording is that it's a floating 10-year period, so it has no fixed benchmark. And I can't see how that provides any certainty to the farmers that you're concerned about.
So for this, if a farmer is putting in an offal pit today, he would look at the preceding 10 years. If he puts in an offal pit in 5 years' time, he would look at the 10 years preceding those 5 years' time. And this is to provide for changes in the groundwater table as a result of, for example, other water abstractions for large-scale irrigation, for example, or for climate change-related variations. And so that floating allows the council to adapt to the changing groundwater levels rather than tying it to a single time frame, which is the problem with June through August in the highest seasonal groundwater levels.
Well, the other issue with the previous definition was that we have now some highest groundwater levels being occasioned by irrigation schemes such as Central Plains, which they don't occur just in the winter. They predominantly occur when the irrigation is occurring, which is in the summer. So there's a whole bundle of issues there. But
There are.
all right, thanks for your answers.
Thank you.
Just in terms of the definition that you're seeking for what I call IFISH, IFSH,
Yes, sir.
is an abbreviation, and it's on paragraph 38, bottom of page 8. Do you agree that a definition in a plan needs to be clear and enforceable
Yes.
and not subject to third-party subjective assessments?
I think that would present a problem for quite a few of the Indigenous biodiversity provisions in district plans around the country.
That wasn't my question. My question to you is, do you agree that definitions should not be subject to third-party subjective assessments for their validity?
Would a SQEP hired by the council be considered a third party?
Didn't hear what you said then, sorry.
Would a SQEP hired by the council be considered a third party?
I still didn't, a what applied by the council?
A suitably qualified and experienced practitioner.
Well, that's still a third-party subjective assessment. A definition needs to be clear and understandable on its face to a layperson.
Yes, I understand. So I submit that actually an expert employed by the council is not a third party if they are employed by the council because they are an agent and representative of the council.
Turning now to the issue you raised about management plans, which is at your para 46. I understand the point you're making where what I call an entry condition to a rule refers to a farm environment plan but not a management plan, and Rule 540 is an example of that. But the other rules that you referred to, 8.5.9, 14.5.4 and 14.5.7, the FEP is not an entry condition to the rule. So the absence of a farmer having an FEP doesn't preclude them using that rule. The FEP is simply referred to as a matter of discretion. So it's a matter on which conditions can be imposed or that decision makers can take into account, but the lack of an FMP doesn't deny a farmer entry to that rule. Is that your understanding too?
So you're referring to 5.40A?
No, I'm referring to 14.5.4, 14.5.7 and 8.5.9, where the FMP is not an entry condition to the rule.
Just give me a second, sorry.
Have a look at 8.5.9. So what I call the entry conditions are the conditions 1 through 4. They don't mention the FEP, so the absence of an FEP doesn't bar entry or use of the rule.
And this is 8.5.9.
Yep. And so the FEP is referred to in matter of discretion 14. So it's a matter that decision makers can take into account and or impose conditions in relation to.
I understand what you're saying. And sorry, what was your question?
I was merely trying to point out to you that I don't think your concern relates to all of the rules that you've listed. You were saying they're not available to farmers, sheep and beef farmers who have a management plan, not an FEP. And I was just wanting to point out I don't think that is the case.
For some of those rules, I take your point on board. Thank you, sir.
But in terms of the one rule you do refer to, 5.40, where the FEP is an entry condition, if the officers could just look at that, and if there is scope to address the issue whereby a farmer with a management plan who doesn't have an FNP might wish to use that rule, whether there's scope to address that issue. So it applies to some of the rules you've identified, I think, but not all of them. Now, in terms of grandparenting, you're right. Beef and Lamb's advocated to every plan change hearing and the original plan itself a natural capital approach based on LUC land use. There's a whole bundle of issues related to that, which is why ECAN hasn't adopted that approach. But in terms of the relief you've sought, you talk about towards the end of your section E, you talk about table 8.9 and the Waimakariri zone and table 14ZC and the OTOP zone, which are the nitrogen loss reductions required over time. Your actual submission merely sought deletion of those tables and replacement of them with an LUC natural capital based approach, which we would probably be loath to do since it goes against the whole grain of the rest of the plan. Have you actually looked at those tables and in terms of the concerns that you've expressed, have any thoughts on amendments to the provisions that are actually in those tables or the associated policies to meet your concerns without deleting them and replacing them with an LUC-based approach? I mean, can you help us if the concerns you've addressed, assuming we're not going to delete the tables and impose an LUC natural capital approach only for those two sub-regions, have you thought about any other amendments?
I do take your point, and I'd like to preface this by sort of I represent Beef and Lamb, and Beef and Lamb's core policy position is that we do not support grandparenting and we do not support provisions which propose or reinforce grandparenting. So that's to preface what I'm about to say. And so where I have asked for the deletion of those provisions, it's in line with Beef and Lamb's core policy stance. And so I have attempted to address this very matter of the particular provisions through our submissions and through this advocacy statement by highlighting the fact that the floor set for Waimakariri is essentially a dry land floor for an extensive system where you've got an ability to use irrigation and winter grazing, which will raise your nitrogen number. So the floor is essentially too low. The floor for sheep and beef, the floor for all other. I cannot speak for the arable sectors or horticulture. I can only speak for the dry stock sector, and the floor of 10, where you're using irrigation above that threshold and winter grazing above that threshold, is too low. And for OTOP region, a major issue is that there is no floor, which means that one can be a very low leacher and still have to make reductions ad infinitum until they've achieved those percentages, and it is simply not achievable. Does that answer your question, sir?
Not really, but Dairy New Zealand have sought that in terms of the OTOP table 14ZC, that the same provision that applies to table 8.9, which is the reductions only having to apply for each stage if they're greater than 3 kilograms of nitrogen per hectare for dairy and 1 kilogram per hectare for all farming activities. They've thought that I think they've thought that same provision applied to that table. Is that an outcome you'd support?
I was under the impression that the two tables differed because modelling had been done to establish what reductions were needed in those different subregions. For example, the soils in Waimakariri are very different to those in OTOP. That was my impression. And so if the actual environmental outcome can be achieved by simply substituting the tables, then that's something that maybe Canterbury Regional Council could look at, bearing in mind that, in fact, 10 kilograms of nitrogen is too low a floor, and where that doesn't further disadvantage the lower intensity systems, for example, by requiring greater reductions than what is already required.
All right, thank you. No further questions.
Thank you.
Mr. Solomon, do you have any questions for Ms. Phillips?
No, I don't have any questions for Ms. Phillip, but I do have some for Ms. Coates when it's her turn.
All right, thank you. Well, Ms. Phillips, the statement that you've presented to us, and thank you for it, it is, as you say, an advocacy statement.
Yes, sir.
And one understands that sometimes advocacy has a different flavour about it than what we might expect from your expert witnesses.
Yes, sir.
But in listening to an advocacy statement, one needs to be alert to hyperbole.
Thank you, sir.
And a couple of times you've used the word penalise.
Yes.
Paragraph 47 as an example. And penalise implies a deliberate punishment for fault. Now, I don't see that that's a word that correctly describes what the Regional Council has done in its proposed Plan Change 7. Do you agree?
I agree that this is not being done through Plan Change 7, but rather through the Canterbury Land and Water Regional Plan generally. And although it might not have been deliberate, it was done without trying to mitigate. And I do not necessarily agree that penalise would be the wrong word, where reward would apply to, on the inverse for the high impact systems, sir.
In your section on grandparenting, you use a phrase, take a haircut.
Yes, sir.
Paragraph 60 and 69.
Yes, sir.
Now, again, I understand that this is an advocacy statement,
Yes, sir.
but I was thinking that this was going to be a serious statement on important matters,
Yes.
rather than a piece of amusement with colourful language. I don't think that I have a clear understanding about what you mean by this phrase, take a haircut. I give you the opportunity, if you wish, to use plain language to explain what you mean.
I appreciate this feedback, sir. What I mean by taking the haircut, and I do apologise for using such a colloquial phrase, what I mean by taking the haircut is to having to make reductions across the board of the low impact users. So having to make a percentage reduction or having the disadvantage, sir.
So it's related, isn't it, to the other question I was asking about penalised.
Yes, it is related.
Thank you. Now, we've had your summary, which I'm sure is a very comprehensive summary of Beef and Lamb's case, and we're grateful for that. You brought your witnesses along, and shall we proceed to see if there's any questions for them?
May we start with Ms. Coates?
Thank you. Ms. Coates, thank you for your statement.
Thank you.
We're grateful for it. Are there any corrections or updates that you ought to give us?
Not specifically. I would note, though, that I have seen a slightly updated version of the planning maps just by chance when I was looking through the ECAN GIS website. Would have been a couple of weeks ago. So I'm aware some of my recommendations, anyway, appear to have been considered by whoever created that layer.
Splendid. All right, well, thank you. Let me see then if there are, we have, of course, read your evidence statement and see if my colleagues have any questions for you on it. Commissioner Van Voorthuizen?
Yes, have you had a chance to view the rebuttal evidence lodged by Christchurch City Council expert witness Dr. Belinda Margetts, where she addresses your evidence?
The rebuttal evidence, I don't think I've seen that. I've seen her original evidence.
Okay.
I have had a brief chat to Belinda. I knew she was going to be referencing my evidence in her rebuttal evidence, though.
She raises three concerns with the suggestion that the IFISH mapped area should be verified by a separate expert survey. First of all, she says it would make for a complicated permitted activity status, as surveys would be required that would then need to be audited by ECAN. She says, secondly, the surveys need to be undertaken in the summer months to ensure accurate results. And that would mean timelines for obtaining data are restricted. And probably more importantly, her third point of rebuttal to your evidence is that she says the lack of fish presence at the time of sampling does not mean that the fish are not present. And she points out that the provisions are designed to protect the habitat rather than where the species may physically be on any particular day.
Yes.
Do you wish to respond to any of those issues?
So the summer surveys, summer months is perhaps a little small. Fish surveys you could undertake any time from around about October through till April or May, obviously depending on elevation. For example, you wouldn't survey way up the back of Mackenzie country if there was snow on the ground. But weather year to year varies. So there's room for, I guess you'd say, expert opinion, or not opinion, but expert knowledge to influence that period of time. With regards to, sorry, what was her last point?
She says that the lack of fish at the time of sampling does not mean that the fish are not present, and she makes the point that the PC7 provisions are designed to protect the habitat of the species rather than where the fish might actually be on any particular day.
Yes, so that's the nature of surveys, is that you're not guaranteed to get everything that you want. You can go out 2 days in a row and get completely different, well, not completely different, but you can get different fish assemblages. with using a suitably qualified practitioner, you would be able to include an assessment of the likelihood that that habitat is suitable for any of those species in that list. Some of those species have got very specific habitat requirements, and you would not find them in certain sections of the main rivers. The braided rivers, for example, have got infinite different types of habitat almost that are not suitable for all of those species, but some areas are. So in that assessment, while it would be, I guess I wouldn't necessarily use the term that it is a subjective assessment, it's still an objective assessment. You couldn't just have, Joe from down the road couldn't just go out and do that assessment. It would have to be a suitably qualified practitioner, and that's where that comes around. So suitably qualified obviously is someone who's got experience in fish surveys, fish habitat, fish ecology, who's able to make that decision. And then with her other point, I think that was around them being audited by ECAN. That's a common practice anyway. I don't see that that is overly onerous. Every resource consent application is read by someone who is qualified to discuss that.
Okay. Are you aware of the, earlier in the hearing, we had a presentation from the Department of Conservation, and they relayed to us the work that I think it was, might have been Dr. Dunn, but I might have the wrong expert for DOC. Anyway, the relevant DOC expert had done a lot of work with the relevant ECAN expert, and they'd refined a lot of the mapped iFish areas, and I think you briefly referred to some amended maps. But are you aware of the detailed work that they've done to review and refine the mapped layers?
I would have assumed it would have happened based on the problems I guess I encountered. I didn't do a full in-depth check every single layer, every single waterway. I checked where the obvious standout errors were. So after that, and knowing how many other people questioned the accuracy of these maps, I am glad to hear that they have gone back and essentially reanalysed what they've done.
Yeah, that wasn't my question. My question was, were you aware that that work had been done in cooperation between DOC and ECAN?
I wasn't aware. I didn't know it had been published, or,
Okay.
as I said, I had seen some updated maps, so I knew something had happened.
Yeah. All right. No further questions. Thank you.
Mm-hmm.
Commissioner Solomon?
Yes, thank you. I've got several questions for Ms. Coates. I'm a little confused by your paragraph 32, where you say, in your experience in undertaking fish surveys.
Yes.
Oh, sorry, I've got the wrong paragraph. I'll just go there now. In your experience, you've never proposed or assigned an ecological value to an area based on a record that is nearly 100 years old without verifying that record with a specific survey. I presume you read the report titled Prioritisation of Native Aquatic Species, Habitat for Protection under the LWRP Omnibus Plan Change.
Yes, I have. I don't have it in my memory. I have read through a number of those supplementary reports, though.
Well, the report says on page 2, to explore the implications of excluding historic data on fish distributions, the 1st of January 2000 was set as the arbitrary cut-off date, with records older than this date considered historic and not used for the planning maps.
Okay. So that was in...
That's in page 2 on the report.
Well, then I don't know how there can be so many records older than that used. So there are... I've gone through... What I went through and did is I downloaded Canterbury freshwater fish database records from the database held by NIWA.
Yep.
And then I overlaid those records over the layer. And then I've been able to filter out, obviously, the irrelevant ones.
So the report also said that the New Zealand's freshwater fish database wasn't the only source used.
No, I'm aware of that.
Online surveys led by Canterbury Regional Council with other data provided by universities, Crown Research Institutes and consultancies were also used.
Yes, and so that information wasn't available in the layer, so I could only go with the information that was available. If it was publicly available, what information fed into each iFish, that's a good way of saying it, it's not the easiest acronym to say. If that information had have been present on the iFish layer originally, it would have been much easier to essentially agree or disagree with that information.
So you read the report that underpinned the mapped layers?
Yes.
And in that report, it had all this information, but you're saying that you couldn't access the other databases that contained that information.
Yes, so the public survey, for example, for the freshwater mussels for Kakahi, that information wasn't available on that layer. I understand that it is now available on that layer with the most recent updates.
Okay, let's clarify that. What was my next question? Now should we accept that ground proofing surveys should be completed at each site before the location of the, I call them CHIFs, is finalised? How many survey visits would you suggest is needed to confirm whether at-risk species are present or not, given your inference at paragraph 8 that says if a survey is undertaken and at-risk species aren't found, doesn't necessarily mean they're not there?
So I wouldn't necessarily say there had to be a survey before this layer was published. It's more along the lines of this permitted activity, if this rule is used as a permitted activity, or not permitted activity, if this rule is used, is used. Do you know what I mean by that? Sorry, that's a roundabout way of saying it.
Well, what I'm understanding that paragraph to mean is that before the layers are confirmed.
What paragraph number, sorry?
Paragraph
30, sorry, I heard 8.
I'm presuming what you mean is that before the layers are confirmed, that they should all be surveyed. Those areas of waterway should be surveyed.
Not necessarily before they are confirmed, but before the activity that those rules, that suite of rules relates to, is instigated.
Right.
So if none of the activities that the rules relate to ever occur in that area, it doesn't matter.
So how many surveys do you think should occur before the rule was initiated?
In the appropriate time of year, one survey by a suitably qualified practitioner would be sufficient, because they would then be able to determine, if no fish are found, is that habitat suitable for the fish to be present.
Right.
So this, if I'm writing an assessment of effects for a resource consent and I don't find fish that I expect, I don't discount their presence. But if that habitat is not present, then I would be more likely to discount their presence. So that would be the method that other SQEPs would employ as well.
Let's clarify that for me, thank you. And my last question is about at your paragraph 52, and I'm not quite sure. Are you requesting in this paragraph that in order for river habitats to be connected, the length and the width of critical habitat areas should be extended?
In this paragraph, I'm really referring to the fact that on some of these rivers, you'll have several different points designated as iFish areas on one river with no connection between these areas. So you're protecting spots. It's a spot protection for the sake of protecting it, whereas these fish aren't necessarily confined to just that 100-metre stretch, for example. They do travel up and down. They migrate some migrate to the sea, some migrate longitudinally depending on their life cycle.
So is your inference, though, that these areas should be connected? so that they can move up and down.
My inference is that why would you protect some areas and not others? So yes, essentially it is.
Okay, thank you. I have no further questions.
Thank you.
Right on, please. Commissioner Shepherd, I just have a follow-up question, if that's okay, based on Commissioner Solomon's line of inquiry.
Thank you, if you will.
So, Ms Coates, I had understood, it seems mistakenly, that Beef and Lamb was suggesting that the identification of these areas in the planning map should be verified by any suitably qualified practitioner before those areas could be placed in the maps. You've now told us that that's not the case, that Beef and Lamb is seeking that the mapped areas are verified by an expert assessment at the time of consent application. But, of course, these areas are referred to in a number of permitted activity rules. So are you now saying that before any person in the region wishes to rely on a permitted activity rule where the iFish mapping layer is invoked, that they would need to get an expert assessment done before undertaking what would otherwise be a permitted activity?
So if I may,
Lauren.
Ms Coates is not a planner, and her scope of evidence relates to the ecology rather than the actual rules, so
Yeah, I don't think you've called a planner though, have you?
no.
Okay. All right, well, I can't take that any further, thank you. That's all, Commissioner Shepherd, no more from me, thank you.
Well, thank you, Ms Coates. We value your statement of evidence and your contribution today. We'll now take a morning break and we'll resume in a quarter of an hour. If everybody's ready, we can continue now. Are we going to hear from Dr. Crystal next?
Yes, please.
Good morning, Dr. Crystal. Thank you for coming in. We have read your statement of evidence. Thank you for it. Are there any corrections or updatings that you would like to bring to our attention?
Tēnā koutou katoa. No, I have no corrections or updatings.
Well then, perhaps we'll go to questions. Commissioner Van Voorthuizen, any questions of Dr. Crystal?
No questions, but I think the matters you raise in your evidence are consistent with what we've heard from a number of farmers who've come before us, so, but no questions, thank you.
Thank you.
Commissioner Solomon?
No, I have no questions either, thank you.
Nor do I, Dr. Crystal. So thank you very much for your clear and well-presented statement. Thank you.
Thank you.
Now we have Mr. Bird, is that right?
Correct.
Good morning, Mr. Bird.
Good morning.
We've read your evidence statement too. And I should give you the opportunity to tell us if there's any corrections or updatings that you wish to bring to our attention.
A couple of minor ones. I've noticed the y-axis on a couple of the figures have no measures on them, so they need to be updated. Figures 21 to 24.
Thank you.
Now that'll be kilograms per hectare. Oh. Otherwise none, Commissioner Shepherd.
Yeah. Thank you, Mr. Bird. Commissioner Van Voorthuizen, any questions of Mr. Bird?
No questions, but again, your evidence is consistent with certainly, I think, what we understand about the nature of sheep and beef farming and the sector in general, so thank you very much.
Commissioner Solomon.
No, none from me either, thank you.
Well, thank you, Mr. Bird. Again, well-prepared statement and helpful to us. Thank you for coming in.
Thank you.
Now, Ms. Phillips, is there anything further that you wish to be saying on behalf of beef and lamb?
No, thank you, Commissioner, and thank you, all of you, for your time and attention today.
Thank you. Well, I think the next submitter on the order, Mr. Scott, has vacated his slot. So perhaps we now come to the Sparrow Family Trust. Are they represented this morning?
Commissioner Shepherd, they're not due in until this afternoon.
Oh, right. Are any of the others due this morning?
No.
All the rest of this afternoon?
Yes.
That's 2 o'clock, is it?
Yes, that's correct.
Well, thank you. We'll sit again at 2 o'clock and hear the rest of the order for the day.